The next speaker, Brigadier McDade, has similarly got a very high profile in the area of military justice in Australia, and has enjoyed a fair bit of media coverage in recent time arising out of her work in this area. To give you a little bit of background into Brigadier McDade, she is, of course, a lawyer, having graduated from the University of Adelaide in 1980, and then has had a fairly varied career in commissioned to the General Reserve of the Australian Army Legal Corps in 1983, and then in 1986 transferring from the reserves to the regular army, then in 1995 transferring back from the regular army to the reserves, and then in 2006 transferring from the reserves back to the regular army when she was appointed as the Director of Military Prosecutions for the Australian Defence Force. During her times when she was reserve rather than full-time, she practised as a barrister in Darwin, and was involved in a number of interesting cases in criminal law, coronial inquiries and administrative law. In my brief opportunity to talk to her during the lunch break, she assured me that she wasn't and couldn't be controversial today in her presentation, but from my chat with her, I feel confident in guaranteeing that she will be interesting, and she will talk about the history and the statutory framework of military justice in Australia, and discuss how it operates within the ADF, with a particular emphasis on the rights and protections provided to service members. Please welcome Brigadier McDade.
Well, thank you very kindly. I might say that I've been very careful in relation to the invitations I've accepted to speak in the last 12 months, and you'll probably appreciate why. But I do thank the organisers for the opportunity to speak with you today in relation to the mystery that is military justice. Generally speaking, military presenters always start their presentations with a joke. Unfortunately, I've had to delete the joke from the repertoire, given that I don't know any of you. I don't know that a word I might say in relation to that joke could be offensive to any of you. And given that defence, if in the event that I was to in any way be offensive to you, would no doubt have another inquiry, I am not about to enjoin you with a joke. Rather, I will commence, because I think it might be much more interesting in question time, and I do apologise that this presentation is somewhat dry, and I did mean it when it was going to be non-controversial, in essence, in relation to its structure in any event. Historically, military discipline has been harsh. As long ago as Cicero, he commented, "The general was at liberty to behead any man serving in his camp, and to scourge with rods," I'm not quite sure how that worked, "the staff officer as well as the common soldier. Nor were punishments inflicted merely on account of common crimes, but also when an officer had allowed himself to deviate from the orders which he had received, or when a division had allowed itself to be surprised or had fled from the field of battle." I can assure you that in 2011 that is not reflective of military justice or discipline in Australia. In the 19th century, Britain reformed its military justice system with the enactment of, in 1847, the Naval Discipline Act, and in 1879, the Army Discipline and Regulation Act. It may surprise many of you here that those acts, as amended from time to time, formed the basis for the Australian military justice system until 1982. For 82 years of federation, we were still relying upon legislation passed in the United Kingdom in relation to our three services. In 1982, of course, the Defence Force Discipline Act was enacted, and prior to that, the Army, the Navy and the Air Force each had different systems of discipline. And each of those were based substantially upon their British equivalents. In relation to the Army prior to 1982, two systems operated, dependent upon whether or not the Army was at home at peace or on active service overseas. The Defence Force Discipline Act commenced operation in 1985, and that was the first time since Federation that the three services, the Army, Navy and Air Force, operated under the same legislation, whether they were at peace or an overseas service. The process in getting to the Defence Force Discipline Act was long and arduous. It took some 39 years in its gestation process. The first committee sat after the Second World War in 1946, and the Act commenced operation, as I say, in 1985. And it was the first time the three services were actually disciplined pursuant to Australian legislation. If anyone is particularly interested in this long and rocky road to the coming of the Defence Force Discipline Act, I do recommend to you a book by Neil Preston entitled Military Law in the 20th Century Australia, The Development of a Common Disciplinary Code. Neil Preston was a public servant who was involved throughout most of the process. He was a member of the Department of Navy, and he's written a book. I won't say it's the best written book I've ever read, but some of his anecdotes and some of his descriptions of the persons involved is quite surprising and indeed frank, and it can make one understand when one reads it why it took so long to bring such divergent views, interestingly, between Army, Navy and Air Force together to be able to come to a common code. So in 1985, the question was then to be asked, bearing in mind that Australian soldiers, sailors and airmen are still Australians, irrespective of the fact that they also happen to be members of a disciplined force. They are subject to the ordinary criminal law and to service law. Given that we'd now come together with a code that was applicable at peace and in war, the question was going to arise sooner or later, and it did, as to which jurisdiction should exercise control over soldiers in the event that they committed offences that were service offences as well as criminal offences. And that question arose particularly when those offences occurred within Australia. Because you'll appreciate a fundamental international human right is that you really shouldn't be punished twice for the same type of conduct. And it didn't take long for this issue to go to the High Court. And indeed, it's been to the High Court on a number of occasions, but it firstly went there in the matter of Re Tracy ex parte Ryan. Staff Sergeant Ryan had been charged with an offence under the Defence Force Discipline Act of making a false document, Section 55. There was a like civilian Victorian offence. He was also charged with 2 associated charges of AWOL. In fact, the document he allegedly falsified was his leave application, interestingly enough. He sought, after being brought before a Defence Force magistrate, that a writ of prohibition should issue against the Defence Force magistrate and to stop him hearing and determining the false document charge on the basis that there was a civilian equivalent and he should really be dealt with in the civilian courts. And what's more, the Defence Force magistrate, being a service tribunal, had no jurisdiction to hear and determine the matter against him, because to do so would exercise the judicial power of the Commonwealth, and of course a Defence Force magistrate had not been created pursuant to Chapter 3, as indeed all the service tribunals. The Commonwealth had relied upon the defence power to create them. Staff Sergeant Ryan also raised the question of Section 80 and his right to trial by jury on the basis that the charge that he would have faced in the civilian jurisdiction would no doubt have been indictable, and he took the view, therefore, by being heard by a Defence Force magistrate, he was being denied his right of trial by jury. I might say that the majority, interestingly, dismissed that argument pursuant to Section 80 very quickly, indicating that it was a matter for Parliament to decide whether or not service offences were indictable offences. But the court was significantly divided about whether or not the defence power could be used to create a discipline system, creating tribunals that could determine matters and not be created pursuant to Chapter 3. You appreciate that Section 51(6) of the Constitution empowers the Commonwealth to legislate with respect to the naval and military defence of the Commonwealth and the several states, and the control of the forces to execute and maintain the laws of the Commonwealth. The court held 5-2 that the Service Tribunal had jurisdiction to hear and determine the charges, But I have to say that even amongst the majority, it was difficult to get a decided common ratio. There were different reasons as to why, in the circumstances, they held that on this occasion the Defence Force Magistrates trial could go on. In that original piece of legislation that went to the High Court in Tracy's matter, the government had also attempted to overcome the issue of double jeopardy. That is, it had tried to say, in the event that you are dealt with in the military context for offending, you cannot then be taken to the civil courts for like offending. The High Court struck that provision down unanimously. The view was taken that you could never oust the civilian jurisdiction. So in essence, as a consequence of that case, theoretically, it was possible for a person who was a member of the Defence Force to be dealt with by the military and then subsequently by civilian authorities. I can tell you that in my experience that has never happened, and indeed now there is existing memorandums of understanding between my office and all the directors of DPPs in every state and territory whereby jurisdiction is worked out before it is exercised. The matter again came back before the court on similar issues 2 years later in the matter of Re Nolan ex parte Young. Staff Sergeant Young, interesting they're both staff sergeants, was also charged with doing things to documents. He was charged with making and using a false document. Now, this was the first time that Section 61 of the Act had been used, and perhaps by way of background I should explain to you that Section 61 was a shorthand version whereby the laws of, at the time, the ACT were applicable to members of the Defence Force. So if it was an offence in the ACT, it was also a service offence, effectively. So that picked up the make and use false document. So it wasn't one of the code, if I can put it in those terms, sections contained within the Act, but it was a pick-up in the shorthand version of laws in their application to the ACT, and I think it was the New South Wales Crimes Act in its application to the ACT in 1989. As we speak, because the ACT subsequently got self-government, it now becomes the laws of the Jervis Bay Territory that picks up with Section 61. So it was interesting in that sense because in the matter of Ryan, it had dealt with sections that were contained particularly within the Act and were known as service offences. Now, Staff Sergeant Young was a pay representative, and you appreciate that gave him plenty of opportunity in relation to false documents, and I bet you can guess which document it was that he falsified. Pay sheets. At the time, the Australian Defence Force was moving towards net pay deposit, that is, direct payments into bank accounts. Well, the intrepid Staff Sergeant Young was of the view that that didn't particularly suit him because that would mean he'd only get paid fortnightly. So what he did was to continue, and there was an option at the time, to be paid in the old way, which was the old pay sheet and presentation at the cash office. So what effectively he did for some little time was to pay himself whenever he fancied. So if he fancied that he needed some money on a Tuesday, he would pay himself. He might do it again on the Wednesday. And until such time as everyone had to move to net pay deposit, his defalcations were not noticed. So you can appreciate it was becoming a significant sum of money. The court in this case held 4-3 that the tribunal, and again he went before a Defence Force magistrate, had jurisdiction to try and hear the charges against Staff Sergeant Young. Mason and Dawson said the following, that it was really open to Parliament to provide that any conduct that constitutes a civil offence should constitute a service offence if committed by a defence member and be triable by a service tribunal. Justices Brennan and Toohey were of the view, if the prosecution could reasonably be said to maintain or enforce service discipline, then the charges could be dealt with by a service tribunal. What we have loosely called the majority decision was reaffirmed by the court shortly thereafter in 1994 in the matter of Re Tyler ex parte Foley. Wing Commander Foley was charged with theft of about $25,000 under Section 47 of the Defence Force Discipline Act, an offence that was substantially similar to Section 71 of the Crimes Act 1914, and he was also charged with breach of a lawful general order. The circumstances being that he was in receipt of rental allowance after he had purchased a home in his posting locality which was suitable for his family's composition, and he'd continued to rent out the home he'd purchased. His failure to advise appropriate authority of the purchase of the home and his change of circumstances constituted the basis pursuant to which he was charged with breach of the lawful general order. Essentially, the court decided much along the same lines. It was certainly not a majority decision, but what was discerned from this trilogy of cases was this: service tribunals can exercise jurisdiction over defence members for service offences that may be substantially similar to civil offences, provided that the proceedings can be regarded as substantially serving the purpose of maintaining and enforcing service discipline, and that service tribunals can stand outside Chapter 3, and the disciplinary code created by the Defence Force Discipline Act was constitutional. In 1994, there was a generally held belief that that was the situation, and indeed it was pursuant to that belief that service tribunals continued to sit throughout the 90s and indeed into the early 21st century. In 2003, the Senate and Foreign Affairs, Defence and Trade References Committee commenced their inquiry into the effectiveness of Australia's military justice system. I don't know if any of you were involved in that inquiry, but it was particularly concerned with administrative matters of military justice, not necessarily the military discipline system. In 2005, they delivered their final report. In relation to the disciplinary system, they made some 23 recommendations. One of the interesting recommendations the committee made, touching upon this particular aspect, was that the ADF should not investigate or prosecute offences that had a civilian equivalent unless the civilian authorities had declined to investigate or prosecute the matter. In relation to the creation of the position of the Director of Military Prosecutions, the committee recommended essentially that the government hurry up. And the committee also recommended that the Australian Defence Force replace its court-martial and Defence Force magistrate system with a military court established under Chapter 3 of the Constitution. The government did not agree to the automatic referral of equivalent civilian offences to civilian investigating and prosecuting authorities. However, they did agree to abolish the court-martial and Defence Force magistrate system, but they did not agree that they would replace it with a Chapter 3 court. They took the view that they would establish a court pursuant to the defence power standing outside Chapter 3, but taking many of the essential ingredients and features of a Chapter 3 court. And they also agreed to hurry up the establishment of the Director of Military Prosecutions. Now, there were many other recommendations that were made, and if you do feel like some light reading, I would recommend that Senate committee report to you and the government's response. But I do recommend that you don't read it all at once. Take some time, and I would make it about 30 minutes a day, and you'll probably finish it within the year. At that point in time, another interesting event occurred that brought the Defence Force Discipline Act before the High Court again. And it had been before the court in the intervening years, essentially concerning Section 109 of the Constitution, whereby we had intrepid soldiers that had been caught on defence land drunk driving by civilian police. You appreciate their public lands, they were in those days in relation to our defence establishments, so therefore you still had the dichotomy of law, and soldiers that had been caught drunk driving by civilian authorities had this possible sanction, of course you appreciate, of loss of licence. Under the Defence Force Discipline Act there was no such penalty available, and these particular soldiers had gone to the High Court to take the view that they wanted to argue that defence had sole jurisdiction on defence bases, and they didn't really want to go to a civil court at all. So we had a couple of reverse twists in relation to it in the intervening years. And then we came to the matter of ex parte Alpert. Alpert is a very interesting matter in the sense of the basis pursuant to which the High Court had established that there was jurisdiction provided it maintained and enforced service discipline. It had always done so by way of a service connection test. That is, we would look at the indicia pursuant to which the offending had occurred, where it had occurred, the circumstances of it and the like, and make an assessment as to whether or not it should appropriately be dealt with in the service environment and or the civil environment. Albert was quite different. Albert happened overseas and involved the Butterworth Guard in Malaysia. Young Albert and some of his friends had taken leave whilst undertaking the guard and gone to Thailand, where it is alleged that whilst he was on leave, he had unlawfully sexually assaulted a British citizen in Thailand. The question that went to the High Court was essentially this: could a general court-martial hear and determine the charge against him, given that it happened whilst he was on leave and in Thailand? And what was essentially the service connection in those circumstances? I must say that many of us at around that time in 2004 were somewhat surprised by the determination of the court, because it did decide 4-3 that a general court-martial could try Private Albert. And the reasoning of the majority, again, was apparently based upon the service connection, with McHugh saying, "A soldier who rapes another person undermines the discipline and morale of his army. He does so whether he is on active service or recreational leave." And I do recommend to all of you here the dissenting judgment of Mr. Justice Kirby. It is beautifully written and has some very significant arguments to the contrary of the majority in relation to whether or not jurisdiction should have been granted in that matter. I can tell you that, in fact, Private Albert was never prosecuted. The young English complainant decided that she didn't particularly want to return to Australia to give evidence, and so the matter was never prosecuted. The matter went before the High Court again, that is the Defence Force Discipline Act, in White versus the DMP. Shortly after I took up the appointment, a Chief Petty Officer White was charged with acts of indecency in relation to her subordinates in and about Victoria. Again, Petty Officer White was challenging whether or not she could go before service tribunals on the basis they hadn't been created out within Chapter 3, and she apparently wanted to have a county court trial with a jury trial. The court determined 6-1 and finally gave us a clear majority decision that service tribunals had jurisdiction. The Chief Justice saying, to adopt the language of Brennan and Toohey in Tracy, history and necessity combined to compel the conclusion, as a matter of construction of the Constitution, that the defence power authorises Parliament to grant disciplinary powers to be exercised judicially by officers of the armed forces, and when that jurisdiction is exercised, the power which is exercised is not judicial power of the Commonwealth. It is a power sui generis, which is supported solely by 51(6) for the purpose of maintaining and enforcing service discipline. So in June 2007, finally, we all thought it was settled that service tribunals could exercise jurisdiction over defence members for service offences, even where there were civilian-like offences and even where the civil courts were available, provided that to do so would substantially maintain and enforce service discipline. The test was, as I've indicated, a service connection test rather than a status test. Service tribunals also did not have to be created pursuant to Chapter 3 of the Constitution, as they did not exercise the judicial power of the Commonwealth, but those administering those tribunals had a duty to act judicially. So what did we do? We created the Australian Military Court, and we abandoned the command-based legal system, and we replaced it with a court that was not created under Chapter 3 of the Constitution. Particularly, the judges that were appointed to that court were given 10-year terms. It was to be a court of record. It did provide for jury trials, 6-man jury trials and 12-man jury trials. They were military juries. That court operated from October 2007 to August 2008. During that period, there were 13 jury trials, 14 judge-alone trials and 63 sentencing hearings. You'll appreciate, many of you will be familiar with the decision of Lyn and Morrison, whereby the High Court and this time they were unanimous. 7-0 indicated that it was not constitutionally proper to have created a court that really was a Chapter 3 court standing outside Chapter 3. So the provisions of the Act that created the AMC were struck down and deemed to be invalid. As and from that decision, we have reverted back to the command-based court-martial system. And that system operates as we speak and will continue to do so at least for the next 18 months or so. I understand it to be the government's intention to again pass legislation, and this time it is their intention to pass legislation to create the Military Court of Australia under Chapter 3. Thank you.